Good evening. This is Attorney Vince Davis, and this is The Secret, How to Fight Child Protective Services and Win. This is the first night that we're expanding the show from 1 hour to 2 hours, and hopefully we're going to be able to take more calls. In this first show, we're going to have special guests, Attorney Arthur La Cilento from Orange County, who is a CPS fighter. Let's take a call right away from Joanna from North Hollywood. Hi, Joanna.
Hello?
Did you have a story to tell or a question to ask?
Well, I had a story to tell.
Go ahead.
Well, I wish I would have known about this show and this program years before, because I had my son for 3 years and 9 months, and by law, babies and children are put up for adoption in a year and a half. But me and my family's efforts made our situation different. And if the judge had known the real truth and actually seen my efforts, I would still have my son. But in court, you're only given 15 minutes to half an hour time limits to try to prove yourself. And unfortunately, if you can't afford an attorney to fight for you, you lose, even if you're right. In my case, the foster mother had everything. I didn't have a home. There was stability, a place. She didn't have to go anywhere, a place to defend herself to any extent. I struggled and I did everything the courts told me, including getting into a rehab. And during that time, I maintained contact with my son and visited him every chance I got. My family from Oregon and Hawaii got to meet and enjoy my son. And I built a bond with him with love by constantly visiting him. After 6 months, almost my graduation time of the rehab, I got kicked out for a false positive test and was forced to stay in my car. But I did the right thing by going to my son's doctor who delivered him and asked him to take my blood and urine because I knew I was clean. In 2 weeks, I got the results back to my social worker, and in fact, they were. So she still helped me until she got in a car accident. That was about 2 years later, and I during that time, I kept up with my visitations with my son. When I went to court, the judge gave orders to the foster mom to only let me visit my son in her home because I had given a dirty drug test. But because I was such a persistent mother, I kept pushing, so the foster mom let me take my son wherever I wanted to, so our bond grew stronger. I took him to visit my family, to a carnival, to get his hair cut. But then DCFS gave me a new social worker who just all of a sudden wanted to push for adoption. This is already almost 3 years I had my son. So I took my son's father's brother to court to try and get custody, but he had a record, so then I took my dad. My dad had a clear record and rented a little guest house all by himself. When we went to court, after my father spoke up for me, the judge's specific orders that day to the prosecutor side and to the social workers were do not move that child until the grandfather's home is checked. The social workers came and was there for only about 5 minutes and left. When we went back to court, they had already moved my son against the judge's orders. The reasons were because there was an ungated pool where my dad lived. The judge gave the social worker some kind of punishment, but they still had already moved my son. The last time I got to see my son was at the Department of Children and Family Services, and we only got to visit for like 15 minutes. This is the only time that the social worker ever saw me and my son interact at all in 3 years. That was only it. That was it. And it was so uncomfortable. And when I left that day, my son was with a man in the parking lot, and my son saw me and started screaming, "Mama, Dada." So he put him down, and my son tried to run to my car and get in it. And then they picked him up. They picked up my son, and all I could do was drive away with my son screaming. And so when I went back to court, the foster mom, because she went against the judge's orders, she lied. And she said I was inconsistent with my visits, that I never went to go see him. And I was trying to explain it to my public defender that she was lying. I mean, how could they think after 3 years? They gave me 3 years, for God's sake. We already had a bond. And they put my son for adoption. They put him up for adoption after that.
Was he adopted?
And that day, yeah, he was adopted.
How long ago was that?
I couldn't believe it. It's already been, he's going to be 18. He was 3 years old. That's what I'm saying. After that, it's like I went through so many things, I didn't know what to do. I didn't have anybody to help me.
Well,
I didn't have an attorney. I didn't know anything.
Joanna, when he turns 18,
he
can come back to you. Did you know that?
Yeah, well, he's going to be 18 next month. That's why I wanted to do this, because I don't know where he's at. I kept going back to the foster mom's house. I have my daughter. I have my daughter with me, and we went over there, but she moved. She moved somewhere, and she knew where he was at.
You know what, Joanna? I know a private investigator. His office is in Long Beach. If you call me on Monday, I will put you in touch with that investigator, and he might owe me a favor. Maybe he'll help you out and not charge you. So I want you to call my office on Monday, 888-888-6582, and tell them that you talked to me on the show on Saturday, and I'll get the number, and maybe we'll call him together and see if he can find your son.
Thank you. Yeah, because I need advice. I still have another problem that I'm going through right now, and so, but I will definitely call you on Monday.
Okay.
Thank you so much.
Thank you.
I just wanted you to know, because it was like I was a victim. I was a victim, and I never thought I was going to lose my son. He was my son. He knew me,
Right.
And it was like, and I would hate for it to happen to anybody else.
All right. Joanna, thank you for calling, and thank you for listening. Audience, I want to let you know that if you have a problem in a case with a social worker or with the CPS system, it is best for you to call early. And, if you can't find an attorney to help you, keep calling. Keep trying to find someone. Most major counties, especially in California, and it's like this in most of the country, if you call the local bar association, just, dial 411 and ask for the local bar association, they generally have lists of attorneys that they can refer you to for it's not a free consultation. I think LA County charged $25 or $50, but they'll give you 2 or 3 attorneys that you can call or go visit. Well, you can't visit right now because of the pandemic, but you can call them and get a free, get a consultation for $25. Don't wait to the end. This caller that just called, Joanna, she said that this happened when the kid was very young, and now he's going to be turning 18. Don't wait like that. Don't wait to call. Call as soon as possible. We're going to take our first break, and when we come back, I'm going to be answering one question from Katrina, who asked a question on Facebook Live. This is The Secret, How to Fight Child Protective Services and Win. Okay, we're back. This is Attorney Vince Davis, and this is The Secret, How to Fight CPS and Win. Katrina asked a question on the Facebook Live. What do I do about violations about DSS violating my due process to adjudication, ? It's going on 11 months now and no court date set still. Katrina, I'm going to answer that question like you're in California, where I'm licensed to practice law. You should have had an adjudication hearing already, but one of the things that's happening, is the pandemic. Everything's closed down. So I don't know why you didn't have a hearing within, I think it's 60 days in California. You are entitled to have a hearing within 15 court days in California if you press the matter and ask for a speedy trial. But, it's this pesky pandemic that is keeping everyone out of court. I know that I've heard rumors and seen some things published. The entire state of California is trying to figure out a way in every county to have court hearings, even though there is a pandemic. And a lot of courts are starting to use online appearances, through, I know LA County is using something called WebEx. It's similar to Zoom, but, they're having those court hearings. It's not the same as being in court, but it's better than waiting and not knowing when you're going to go to court. I keep hearing hearing that the state might open up in May, but then that was canceled. Maybe it's going to be June. I hear rumors, from people on the internet or in the news media that, we might be looking to August, September, or even later because of the pandemic. But who knows? And by the way, in California, if you're in California, it's not DSS that is causing the delay. it's actually the state of California, the governor and the chief judge, who have shut down, and I think under these circumstances, rightfully so, the courthouses because of the pandemic. They're trying to flatten the curve. But I do think they have to come up with an idea to somehow have online or Zoom or WebEx court hearings where everybody can appear by video. But they're trying to work out the kinks. You know, it's not as easily done as or implemented. For example, someone was telling me, well, we want a trial. And I was thinking, well, if you want a trial online through WebEx, how am I going to get or make your witnesses come to court or come appear at this court hearing and testify? You know, subpoenas make people come to certain places and get on the witness stand. You know, what if somebody doesn't have the, or claims they don't have the technology to testify in court, or online? So there's a lot of things that are going to be, worked out. I hope that answers your question, Katrina. Right now, I want to bring on the line an attorney who I know very well. His name is Arthur J La Cilento. Art, how are you?
Good evening, Vince. How are you tonight?
Doing well. Just so the audience will know, Arthur is an attorney. He's an expert in defending parents and relatives in juvenile dependency courts. I was going to say, Art, mainly in Southern California, but I do know you've practiced in some kind of Northern California, and I heard recently that you're going to be joining me on a case in San Joaquin County.
That is correct, Vincent. And yes, I've done Oakland cases, Fresno. I've done all over the state pretty much as far as dependency. Predominantly LA, Orange, San Bernardino, Riverside, San Diego counties. But I do get cases up in Northern California as well and Central.
All right, before
San Luis Obispo and other counties as well.
All right, before we get too far into this, tell people how they can get in touch with you.
Thank you. If anyone would like a free consultation, my phone number is 714-526-0450. Once again, 714-526-0450.
You know, I've done a number of cases with Art where he's co-counsel or represents another party. Done a lot of cases against him. Done a lot of cases when we're on the same side. And I was trying to think my funniest Art La Cilento story. Art is a fighter, and, you know, he takes no prisoners. And sometimes some judges or judicial officers don't appreciate that, but that's the kind of attorney he is. He's a very strong and very, very experienced attorney in this area. Hey, Art, instead of me asking you questions, why don't we take a call and you answer the question of the caller?
I'll try to help. That's fine, Vince. Thank you.
Okay. Let's go to Janet from Los Angeles.
Hi.
Hi, Janet. You're on with...
How are you? Yes.
I'm good. How are you doing?
Fine. Thank you so much for picking up my call.
Sure.
I actually have very important question, and the callers will have a lot to learn from it. So what happened was that I was visiting my son. The grandfather is not supposed to be monitoring. He monitored, and then he left with my other son. And then I was spending time with my older son. And then what happened is that the grandmother came downstairs, and I got irritated. So I called her. Don't be a kid. I said, don't. I don't want to see your face. I said during my visitation. And she talked with this lady that she had her glass covered her eyes with sunglasses. And it was one of the, I think, residents or visitor at their building. And she said about me. And then that, I have my son sitting on the sofa at the waiting room of the building, and maybe the sofa is not clean. And because people come and from different areas and they sit there, but usually it's for residents.
Hold on, Janet.
Because
Janet,
that's the key. Mm-hmm.
Janet, let me interrupt you for a second. I don't know about Art, but I'm a little lost with this story.
And Joanna, I had a question for you too. Like Mr. Davis, I believe we're trying to say, did your visits get modified or cut off or changed based on this interaction with the monitor and the family?
Yeah, basically what happened is that I'm always nice to them, but they still mean to me, and they cut off my visitation pretty much. That's my question. When they get cut off my visitation, and I fear from like violence, can I just grab my kid and go and do a restraining order if I have a visitation, or I have to just comply and then let them have the kid and then go change and go do a restraining order or modify the custody order?
You have a number of questions there, and I think Vince and I can both tell you. Number one is you want to give visits with how many, is it child or children, ma'am?
Children.
Okay, how many children do you have?
2.
And you have no visits whatsoever now?
It's a 2-2 ratio, which is 2 times a week, 2 hours of visitation.
Right now, are you getting any visits because of the pandemic or the court? Do you have any court-ordered visits that are supposed to go forward right now?
So regardless of the pandemic, I can still visit or no?
Okay. No, wait, let me ask you this. Number one, you said your visits were stopped. Did the court cut off your visits? Yeah, that's the first question.
The court didn't cut off my visit, but what happened is that February 14th, the grandfather fought with me, wanted my kid to be visited in front of his door when it should be a neutral setting, and I don't even understand what neutral setting means.
Okay. This is what you need to do. Number one is, right now, and I think Vincent can tell you the same thing, a lot of parents are not getting their court-ordered visits because they're making people do Zoom and Skype and FaceTime because the stay-at-home order from Governor Newsom. But what you have to figure out, number one, is if, number one, you have a court-ordered visit and they're supposed to go forward, number two, you may want a different monitor. You may have to run into court and get an order for a new monitor if you can't get along with these people. Then number three, you can look at potentially a restraining order if there's domestic violence involved on the visits. So the first thing you want to do is, number one, make sure you have your visits with your children because it's very important. How long have you been in the system, ma'am?
I've been doing this. So what's the point to get a new monitor if it's unmonitored, the visit?
Oh, the visits are unmonitored? I'm sorry. I thought he was your monitor. I apologize. If it's unmonitored, then what you might have to do is, if it's unmonitored, why is the family there? I'm just trying to clarify. Can you please explain to me a little better? What are your exact visits, ma'am?
Huh?
It's 2 times a week?
2 times a week, 2 hours minimum at a neutral setting. And I don't understand what exactly neutral setting means. It means
a neutral setting is a park, McDonald's, anywhere but your home. So it's somewhere or the caretaker's home. So you usually go to a park or wherever you can go neutral, where basically it's a public location. It's not your home or the caretaker's home. That's neutral.
Hey, Janet, let me jump in for a second.
Right.
I'm going to ask Art to give you his telephone number, and I want you to give his office a call on Monday so he can talk further in detail with you about this. Only reason why is we're about to take another station break and pay some bills. So, Art, would you give Janet your telephone number?
Sure. 714-526-0450.
Thank you so much. I appreciate it.
Thank you, Janet, for listening, and thank you for calling in this evening. Keep listening. Okay,
I will.
All righty. Thank you. Art, stay on the line. We're going to take another station break. This is The Secret, How to Fight CPS and Win. Okay, this is Vince Davis. This is The Secret, How to Fight CPS and Win. Art, are you still with me?
Yes, sir.
Okay, Art, we're going to take another call right now from Passion from New York. Passion. Hello. You're on with attorney Vince Davis and attorney Art La Cilento. We're both licensed attorneys in California. We can't give New York advice, but we can tell you what we would do in California with your question. So go ahead.
Okay, so I'm going to give you a little bit of backstory so you understand my question a little bit.
Sure.
So the backstory is I've been dealing with CPS going for almost 5 years. I had a CPS worker that I just got phone call 2 days ago working with the person who has my kids to keep my kids, where they found out the supervisor is the one who called me. They fired the person supposedly, but now I'm only in court for one kid because the other kids, it was give up custody, like lose them completely, or do joint custody, where I end up doing joint custody. Because I'm supposed to be going back, because the lady called and let me know, they are giving me back my child, one of them, because that's the only one I'm in court for. Is it possible for me to get my other kids that's with that person back, or do I have to do a whole new court order?
Art, what do you think about that if she was in California?
If she was in, I just like Mr. Davis said, I cannot give legal advice for a New York case. By the way, how are you doing in New York right now with the health situation? Are you safe, ma'am?
Yeah, I'm safe.
Good. All right, first off, in New York, is this a New York case, or are you living in New York and the case is in California?
I'm really in New York. The case is in New York, too.
And it's a New York case? Okay. I can't give legal advice on New York, but in California, we could always file a motion to have the other child returned if it's not too late, if the child's not been adopted out or things like that. If the child has not been adopted in California, we can file a 388 because a lot of times, I think Vince will be able to explain this to you, the fact you got one child returned shows that you're not a risk to a child. How old is that child?
The one that they're returning is 1. The other one's 3.
Yeah, I mean, I don't know what now the other one that's 3, is it with a foster parent or relative, or where is that child placed?
It's with a relative, because they also noticed my relative's been working with the CPS worker and was not right. And that's why they're returning back my one child, but the other one's not in the case no more. So that's why I was like.
So the 3-year-old, how often are you visiting?
I'm not able to get no visits because of the virus right now, and my relatives won't let me see them, which is another reason why they're returning my one child.
Do you have an attorney, ma'am?
Yes, I do.
Okay. What you need to do is you need to sit down with him or her, or not sit down because of the pandemic. Call and get an appointment with him or her and come up with a strategy to get the 3-year-old back. If you were in California, you would file what Art mentioned, the 388 petition. All right. And that's going to work only if the child hasn't been adopted by your, your relative. So what you definitely have to do is talk to someone, because if you're in California and you got one child back, you should be getting all of your children back if they haven't been adopted. Right?
Yeah, well, my one child, he's not adopted. We have joint custody, but the relative doesn't follow the court order where I'm supposed to be able to see him still. Well, my thought was, like, hopefully everything opened back up May 15th, what they say, and I was going to go down and fill out papers to try to get him returned. So when we go back June 2nd, that's because I'm supposed to get my kid May 1st. So I was hopefully, I could sit there and have the case put for June 2nd when they make it permanent, that he stays here permanent.
Right. Well, definitely talk to your attorney and ask him if there's any type of motion that can be filed to get the 3-year-old back, because you're getting the 1-year-old back. So, if under California law, it's my theory that if you're not a danger to a 1-year-old, how can you be a danger to a 3-year-old? Right? Passion, I want to thank you for calling in.
I was wondering.
Yeah. Thank you for calling in, Passion, and keep listening, okay?
Okay, thank you.
Thank you. Let's take another quick call from Indiana. Katrina from Indiana.
Hello?
Hi, Katrina. Did you have a story to tell or a question to ask?
Yeah, well, I had a story to tell and then basically a question to ask, but I've never actually been, substantiated for abuse of any sort, like a Chin's case or any of that. Everything's actually been, unsubstantiated, but I do have an ex who's just filed, in custody pursuits towards me since, October 6th of 2017. actually.
Well, hold it, Katrina.
And
Katrina, do you have a CPS case in Indiana?
Yes. Well, yeah, and it was unsubstantiated,
Okay,
actually.
Is it over and closed, or it's still going on?
Well, it was unsubstantiated, and they had sent over like a referral to the prosecutor in the county that I live in.
Mm-hmm.
And when they had done that, like, they charged my son with a felony 4 on an unsubstantiated CPS case.
Okay, so but have you yourself gone into a CPS courtroom? Yes, no, or I don't know?
No.
Okay.
No.
So you probably don't have a CPS case. And
I've never had a CPS case. That's why I don't I mean, they have open assessments on me all the time because he has undisclosed conflicts of interest dating back to February 3rd of 2018. And I've called in like 3 complaints to the CPS line, to tell them, like, hey, I've never had a permanent custody hearing set. Like, my sole physical custody of my daughter that I've held since her birth was removed from me in a court hearing.
Well, Katrina, let me do something. Let me suggest this. I think that you need to sit down and talk to an attorney in Indiana.
Yeah, I had one.
A family law attorney?
Yeah, I had one, and she didn't file. She couldn't see my JP case. I actually just received, like, proper service on that on Thursday. This past Thursday, I received public service because I could never see my JP case. It's considered like a confidential case.
Katrina, here's the thing. You have to find an attorney that's going to help you. And
yeah, that's what I'm getting one Monday.
Okay,
and
perfect.
She's supposed to be like the best one in Indiana.
Perfect. Well, in a couple of weeks, call us back and let us know what happened. I'm very curious.
Yeah, I didn't know how they actually pursue criminal charges against like a minor child on an unsubstantiated CPS case, and he's never been arrested.
Right. I couldn't answer that, even under California law, and you're in Indiana.
Yeah.
That is kind of strange, but, get an attorney and follow their advice. Okay. Katrina, thank you for calling, and keep listening, okay?
Yes, thank you. I love you guys so much.
Bye-bye. Hey, Art.
Yes, Vince.
That last caller, what she was saying, I think, is that she was investigated. It was never filed as a CPS case. And it must have been something with one of the minor children. And it sounds like the district attorney's office has picked up the case and filed a case against one of the minors for doing who knows what. To who knows who. And, frequently, just because you have a CPS case that was found unfounded or they don't want to prosecute it, the DA can still prosecute you in a case, and vice versa. Have you ever had that situation or seen that situation?
All the time. And It actually happened, if you look at it, the Michael Jackson case. Social Services in Santa Barbara County, I believe, found it unfounded or inconclusive, and the DA in Santa Barbara was very aggressive in prosecuting Michael Jackson, and he wound up getting not guilty in the jury trial there. And one of the things that can help you, and I think one of the things you'd want an attorney like Mr. Davis and myself, we do juvenile and criminal, and a lot of times we can use the juvenile records if they're trying to come at you criminally in California. And I do that all the time, and I know Mr. Davis does it, because if you file a petition to get the records and they're coming at you criminally, an aggressive DA's office, sometimes Social Services does not have the same agreement as to whether the allegations of abuse or neglect are true or not. So it's really a good way to defend a parent who's wrongfully accused of a criminal charge. If Social Services investigated and found it to be a custody battle or the child recanted, and a lot of times the district attorney will not provide that information. So it's critical, if you're ever wrongfully charged and you're investigated by Social Services, you get those records, which can really help you. I've been able to get cases dismissed that way numerous times.
Very good, Art. We're going to take another break right now. When we come back, we'll take some more calls, and we'll talk more with Art La Cilento. This is The Secret, How to Fight CPS and Win. I just want to remind the listeners that this show is being live streamed on Facebook, and it's at The Secret, How to Fight CPS and Win. Art, are you still with me?
Yes, I am, Vince.
You know, I wanted to ask you a tip for our audience. Let's say you have to appear at your very first hearing, which is commonly known as the detention hearing. You're a parent, they've taken your child away. You've never heard of juvenile dependency court. You know, you didn't know anything really about CPS and social workers, but your child is gone in some strange foster home, and you're coming up with your first hearing, say, on Monday. This Monday, you got to show up into court. What do you think this parent should do?
Number one, contact an attorney that specializes in juvenile dependency law. It's a very specialized area. I cannot tell you how many parents have made the mistake of going to basically a non-specialist in family law or criminal law that has no idea the procedures, how to prepare and do that. Dependency law is one of the few areas in the state of California you must have competent counsel under WIC Section 317. So you must have experienced, specially trained counsel to represent you. And a lot of courts won't even let you go in with an attorney that doesn't have the experience in the area. So, number one, you want to get yourself someone like Vince, who has done thousands of these cases for over 30 years and knows how to sit down and prepare you for this hearing. Because a lot of times you can get your child back at a detention hearing if you go in prepared. You anticipate what they're going to say. You get as much evidence as you can because it's a short time. And if not, you have a right to a 24-hour continuance by law. The judge can't deny it. But you want to get everything you can to show the court you are not a danger or risk to your child or children. So it's critical you call an attorney when they start investigating and not wait till some social worker misrepresents a fact or makes a mistake or the police are getting involved wrongfully. It's critical as soon as social services workers call you, you call an attorney who knows this area of the law. It's like the old saying, an ounce of precaution is worth a pound of cure. So call someone like Vince or myself, who's done thousands of these cases, and we can a lot of times, believe it or not, help you get your child back at the detention hearing. Is that correct, Vince?
I agree with you 110%, Art. Thank you for that tip. I hope it will help some of our listeners. Let's take another call right now from CJ in Orange County. CJ, you're on with Vince Davis and Art La Cilento. Did you have a story to tell or a question to ask?
Actually, yeah, my story is I'm divorced, and my ex ended up moving. We have 50-50 custody, but she ended up moving on her own behest and without telling me or the kids, and then she expected the kids to go with them. Now, this has been going on for 2 years, and the children actually decided, and they're both over 16, they decided to go and stay with me. So where am I as far as child support and visitation and things like that for her?
CJ, are you in Orange County?
Yes, I am.
Okay, I'm going to let an Orange County attorney answer that question. Mr. La Cilento, can you help the gentleman?
How are you doing, sir? Are you in family law court or juvenile court?
I'm actually, it's just family court.
Okay, you're a family law case.
Yeah, but
okay,
we're not even in court, and I haven't even filed that she has left the state yet. So I'm probably a little bit behind on that, aren't I?
Well, here's the issue. Are the children with you?
Yes, they are.
And what's the current order, 50-50?
Yes, it is.
When did
I have them all the time.
Okay, but when did you
might get them? Go ahead.
I'm sorry. When did your ex leave the state?
About 2 years ago.
Okay, well, you can always file paperwork or request for order for modification in family law court where you can ask for full custody, and you can also ask for child support. And the fact is the children have been with you how long now?
They've been with me for 2 years.
Okay, then you need to file. But actually, you really need to do this to protect yourself, because if the current order is in effect, she can come by potentially even with the police and say, I want my children today, the 50-50 order. So you need to go to court and file a request for order to modify the current orders of 50-50, and you can ask for child support on that. And unless you want to make sure what she makes and you make, you don't wind up if you make too much money, I don't know what your financial situation is. But, yes, you can file papers.
Actually, I'm unemployed right now.
Okay. Well, then you should file for a request for order for custody and child support. You absolutely can do that.
Okay. And then what kind of, if considering their age, actually one is 21 now. Well, he'll be 21 in June, and the other one is 16.
Well, you can't file on the 21-year-old. That's too late. But you can file on the 16-year-old, and you need to do that. You need to protect yourself numerous reasons.
Okay. Does she have any rights to them at all, or, I mean, is it the child's decision?
Well, what you need to understand is unless your parental rights are terminated and the other parent has rights, the issue is what's the best interest of the child. And when they're 16 years old, the 16-year-old, there's numerous ways for the court to get what the child wants. The child's been living with you 2 years and now has friends and is in school. You have a good chance of keeping the child with you unless there's some other thing we don't know about. So the court can listen to the child. They can appoint a minors counsel. They can do an evaluation. So you need to file those papers because the one child is aged out and the other one's 16, and that child's going to age out too, and you need to file that. So if you need child support and custody, you need to file the appropriate paperwork. If you can afford an attorney, then you should go to an attorney. If you can't, they have a self-help center at Lamoureux Justice Center, 341 the City Drive, where they'll help you fill the papers out.
Hey, CJ, I want to thank you for calling and thank you for listening. I hope Art was able to give you good advice. If you need to call him and carry on this conversation further, Art, what's your telephone number?
714-526-0450. 714-526-0450.
CJ, thank you for calling.
Perfect. Great. Thank you.
Hey, Art, we're running out of time for the first hour, and I want to thank you for calling in and being a part of this show. But before we let you go, I want to take a question from the Facebook Live, and I'd like you to answer it. Here's a question. Can a 388 petition still be filed during court closures to request placement to be made with family members prior to the disposition hearing?
I'm sorry, I couldn't hear. Can a what?
Can a 388 petition still be filed during court closure to request placement to be made with family members prior to the disposition hearing?
Is it prior to the disposition hearing?
Yes.
Well, you can also file. The answer is yes. I would try to file it. I've been even with this pandemic. I've been filing 388s and motions for relatives under 361-3, or if it's a grandparent, 361-2, to try to get placement. Yes, absolutely. You can't delay. It's critical you file, whether it's a 388 or a motion for relative placement, as soon as you can, and you make sure you serve whoever you know that's involved in the case. And some courts are filing documents. Now, whether the judges are reviewing it quickly, I can't answer that, but I've been sending them in over the last month myself to protect the rights of the relative, because if you delay, the child could bond in a foster family out of a relative placement, and then you lose the case. So a relative needs to act right away to protect themselves by filing the appropriate paperwork as soon as possible.
Okay, Art, thank you very much. Thank you for being part of the show. We're going to invite you back in the future. You're always an asset.
Well, thank you for having me, Vince, and I'm very happy you're trying to help a lot of people that have to deal with the juvenile dependency system. Thank you, Vince.
All right. We'll be back for our second hour after this station break. All right, we're back. This is The Secret, How to Fight CPS and Win, and I'm attorney Vince Davis. During this second hour, we're going to be taking calls, and let's take a call from Annette in Los Angeles. Hi, Annette. Did you have a story to tell or a question to ask?
Hi, how are you? If we have a visitation and then we put domestic violence restraining order, like for the father and grandparents, can I get sole custody?
Are you talking about through the CPS court or through the family law court?
Family law, because the CPS is closed.
The CPS case is closed?
Yes.
Okay, so you can go to family law court and you can file what's called a request for order to modify the custody and visitation order. And if you don't have custody, you can ask for the family law court to give you custody or to give you more visitation.
So even though there is a domestic violence, I cannot do a restraining order, it's going to interfere with the visitation, right?
Well, wait a minute. Who's the domestic violence order against, you or the father?
Domestic violence order, I want to do against the father who has a custody of legal and physical, because he lets the parents to get involved, and the parents fight with me.
Okay, well, you're going to have to do that domestic violence order or request along with your request for order for custody and visitation. You're going to have to do that in the family law court.
Yeah, and do you suggest me to do it? Father stays upstairs, so the father doesn't come downstairs, and the grandparents come downstairs. So, if I do restraining order against the father and the grandparents, will they open CPS case and they can take my kid, or they will give it because they will modify the visitation and give me sole custody?
I can't tell you what CPS is going to do. They might get involved. They may not get involved. It's up to them and the social worker who's assigned to the case. But that could happen.
But not 100%.
No, nothing's 100%.
Yeah, but it shouldn't if I think that could happen, but I shouldn't be scared of that happening and just stay quiet and then I lose, right?
I don't know. I don't know enough about your case and the specifics and the people involved to give you that type of yes or no answer.
Yeah, but the only problem is that's very tricky with the DV restraining order, because if I put a DV restraining order, then if I go there and get my kid, if they call the police, then I'm not supposed to be being close to them either. Then I can go to jail or not really.
Oh no, you could go to jail. But this is what you should do, Annette. You need to find an attorney that does family law and have a conversation with them about the pros and cons of doing what you're trying to do. You could be successful. It could backfire on you. But you definitely need to talk to an attorney. And I don't know if you're doing this, but I would not, if I were you, I would not try to make my own strategies. Because, you don't have the training, the knowledge, and the experience of a lawyer, and you don't have the tools to come up with strategies. Okay, a lot of people, want to come up with their own strategy because it's what they think justice is in their heart. And they're about 5% right. But that means they're about 95% wrong. So talk to an attorney, Annette, okay?
Yeah.
All right. Annette, thank you for calling. I appreciate it. And keep listening. All right, let's take another call. Alexis from Tehachapi. Alexis, did you have a story to tell or a question to ask?
I would say a story to tell. I actually just recently lost my son to CPS about 28 days ago. And
when you say lost, do you mean they detained him or you lost your parental rights?
They detained him. They came with the cops or the sheriff's department saying they had a warrant.
Now, what county is that?
I'm in Kern County.
Okay, Kern County. So you've been to court already?
Yes, I've actually been all the way through. I passed my 6-month hearing, actually. So I've done all my substance abuse classes, parenting. I'm still in that with the coronavirus. It stopped me, so I haven't been able to finish.
Okay, and when is your next hearing?
May 12th.
Now, is that going to happen, because the pandemic's going on?
I'm not sure. I recently got a letter in the mail from my social worker stating that, that's when court is, but I'm not really sure. I don't really get much help from any of them, honestly.
Right. Have you been doing your case plan, your parenting, your substance abuse counseling, your testing, and all of that?
Yeah, I've been doing all the testing and everything. Actually, why they took my son is because they said that I had tested positive for narcotics, which astonished me because I know for a fact I wasn't using, and I'm in pain management for my back, and I had tested for my doctor the same day, and voluntarily tested for CPS, and when they told me that test came back positive, I was in shock. And I gave them proof that I had tested for the other doctor, and it was all negative, and they still didn't care, and they won't give me my child back. And I haven't seen my son in 28 days.
Well, that's a problem, probably connected with pandemic. But, I'm a little concerned. You said, did you have a trial and the judge found against you, or did you plead no contest?
I pled no contest. My public defender told me that, because I kept telling her, I don't have any drug crimes. I've never been in trouble for drugs. There's no factual proof of anything. And she's like, well, look, if you plead no contest to this, we'll put Wyatt back into your care and out of foster care today. So me as a mom, I'm thinking, okay, I'm going to do anything to get my kid back in my house, not realizing how bad that was. If I would have just held out and said no, I probably would have hopefully I would have had a case closed and my son back in my care. And now I made a stupid choice, and I got coerced into making a bad decision, thinking that it was going to be beneficial.
Are you saying that your public defender told you to admit to something that wasn't true?
Yeah.
When something like that happens, you can make a motion to set aside your plea. Has anybody ever talked to you about that?
No.
Okay. Now, I'm not saying that you'd be successful and the judge would grant it, but if your public defender asked you to do something that wasn't true, that might be grounds for it. And by the way, and I want to tell this to all the listeners, if you take a drug screen for a CPS agent or social worker, and it comes back positive, you're entitled under law, state law and federal law, to get a second opinion or get it retested. Not only that, you can ask for the sample to be transferred to one of your own experts for testing. Did anything like those two things happen in your case?
Yeah, I never even knew I could do that. I kept questioning them about it, and all she kept saying to me was, where was Wyatt when you were getting high? That's my son. And I said, what do you mean? Like, I said, I haven't been using drugs. Like, I just kept, and they just keep making it seem like, well, take this time to get yourself together. And I'm like, get myself to, I don't understand what you guys are talking about. Like, I've done everything that they've asked me to do for 11 months now. I feel like it's been since May of last year I've been doing this. So it's been a year. And this is my second social worker, and this one doesn't do anything for me either. She refuses to, text me. I asked her for texting because for me that's be able to hold proof of record of what's being discussed. And if I don't do that, then she could say whatever she wants to me and it's not recorded. Mm-hmm. And, I know you're supposed to record them, but I mean, I've recorded some of my conversations with her. And just recently I recorded my entire visit with my son on the video chat or Skype because of the foster parent's attitude. And she deters my son's attention away from me to her. And then, asked him if he wants to go outside. And he said, yeah. And then there goes my visit. She hangs up on me and that's it.
Okay.
It's like 10-minute visit. All
right. Well, Alexis, I do want to tell you this before we take our next break. it's a crime to record people and they don't know it.
Yeah, I know. That's what I was just told the other day.
So in California, that's a no-no. So don't do that, okay?
Okay.
We don't want to make a bad situation worse. Alexis, thank you for calling and thank you for listening. This is The Secret, How to Fight CPS and Win. We'll be back with more calls and answering more questions. Okay, this is Vince Davis. This is The Secret, How to Fight CPS and Win. You know, we have a question on our Facebook Live, and it's talking about relative placement with, in this case, apparently grandparents prior to the 2-6 hearing. I think in this particular situation, if not parental rights, but if family reunification services has been terminated, you can still file a 388 petition before the 2-6. And I highly recommend that not only a 388 petition be filed requesting return of the child or further family reunification services or placement with a family friend or a relative, but also that the parent file what's called a bonding study. File for a bonding study. One of the ways, it's probably, I think it's only the only way that a parent can defeat a 2-6 termination of your parental rights is by establishing at the 2-6 trial that you have a relationship such that it would be detrimental for the child, for your rights to be terminated from the child. Now, the only way that you can usually prove that is by way of, let's say, a bonding study where a psychologist does an evaluation of both you and the parent, you and the child or children, and determines if you have that type of relationship. In the past, I've had bonding studies done where the parent or the psychologist has found that it would be detrimental to terminate the parental rights and that the child should not be adopted. And of course, I've had bonding studies that have come back the other way, where it says that the parent doesn't have a significant relationship with the child. Earlier in the show, one of the things Attorney La Cilento asked the caller was, were you still visiting the child? And it is extremely important all the way through the case that you visit and that you keep a log of all your visits. Because if you notice, one of the other callers said the foster parent got on the stand and said that I didn't keep my visits, that I was sporadic in my visits. When in fact, according to the caller, she had been visiting all the time and had been visiting every week. So it's extremely important that you be able to have those visits, extremely important that you keep a log of those visits and whatever else other proof that you can do. In some cases, not all, you might be able to take a picture with your child on each and every visit, and then you'll have a photograph. You know, most people, if not all, but most people have a smartphone, and you can take pictures and take videos, with that smartphone very easily. I know some social workers and maybe some even juvenile judges are going to frown on you taking pictures at the visit. But I'm not sure, as long as you're taking pictures of your own child with you and you're not disseminating those pictures like on social media or Facebook, I'm not sure that you can't take those types of pictures. I've been in cases where, someone's brought up, oh, the mother's taking pictures at the visits. The world is, coming to an end. And I've heard, judges make the order, ma'am, you can't take any pictures or videos. But if that's not the order, I'm not aware of any law in California that would prevent that. And it would go a long way to help proving that you are making all of your visits. So when the foster mother gets on the stand and says your visits are sporadic, you can pull out your pictures or have the pictures printed out showing that you indeed have been having those visits. So keep that in mind. Now, one of the things that's been happening the past week, and I've always kind of known this, but it's become crystal clear to me. Many people call me and tell me the social worker decided blah, blah, blah. Okay? I want everyone to understand something. Social workers don't make decisions in CPS cases. All they do is make recommendations. So if the social worker makes a recommendation or decides to do something that you don't like, all you have to do is tell your attorney. And the attorney can go to court, have a hearing or a mini trial on some issue, and hopefully the judge will rule in your favor. And it doesn't matter what the social worker says. I tell my clients all the time, hey, it doesn't matter what the social worker says. The judge makes the final decision. And let me give you this example. It's a story. In many cases, grandparents call me and tell me, hey, the social worker won't give me my grandchild. The parent is, on drugs, the father's in jail, and the child's in a strange foster home, and the social worker wants the child to be adopted by these foster parents. And I'm the grandparent, and I want the child back. But the social worker decided not to give me the child, right? Social workers don't make those types of decisions. And in this particular story, I filed what's called a 388 petition and a de facto motion and some other things, petitions and motions, and it caused the court to rule to have a hearing. And we had a hearing before a commissioner. At this time, I was a court-appointed attorney, so this was many years ago. And I was cross-examining the social worker. And the social worker said, I asked the social worker one last question. I said, ma'am, what's the real reason why you don't want to give the grandmother her two grandchildren? And the social worker looked around, and then she turned and looked at me. She said, and this is not an exact quote, but she said something like this. Well, everyone knows that Jamaicans are drug dealers. And your client's Jamaican, lives in New York, so she must be a drug dealer. That was the reason why the social worker did not give the children to the grandparent. The judge stood up and just walked off the bench. I mean, I guess he was flabbergasted. He was fit to be tied. And this was, early on in my career, and I didn't realize I could sue the social worker for doing something crazy like that. But, unless you get in front of the judge with the right motion, the right petition, the social worker's recommendation is going to stand unless you challenge it. So please make sure that you talk to your attorneys and that you challenge it. Okay? My engineer is signaling me. We have to take another break. This is Attorney Vince Davis. This is The Secret, How to Fight Child Protective Services and Win. We'll be back taking more calls and answering more questions. Okay, this is Vince Davis. This is The Secret, How to Fight CPS and Win. I was looking at the Facebook Live, and there is a person on there by the name of Katrina. Katrina, please call in because I'm a little confused by the couple questions you ask. 800-222-5222. 800-222-5222. Let's take a call right now from Connie in Los Angeles.
Good evening.
Good evening. Did you have a story to tell or a question to ask?
No, sir. I just needed to ask a question. Your last remarks about the judge having the say-so and the social worker could not make that decision. The last little boy in Palmdale or Newhall, wherever he was, his grandmother fought really hard to get him back from his abusive parents, father and mother. Mm-hmm. And the judge, from what I understand, I don't know it personally, but the news information I got on TV and et cetera, was that the judge had ordered that child to stay with his grandmother, but the social worker decided to put that child back in the hands of his abusive mother and father, and they ended up killing him.
You're talking about Gabriel Fernandez?
Is that the one? Because there were two of them. One was the older one, or the first one, and then the second one, which was the most, horrific to me, because it wasn't a mother and father. I think it was a mother and her boyfriend. And the little boy had said he thought he was gay or something.
I don't know the details of that case. I do know that in the Gabriel Fernandez case, the child was with the parents, and apparently there were definite signs of abuse, and the social workers did not remove the child from the home. I know they were sued. The county and the social workers were sued. I thought I read someplace where the case might have settled for $5 million or $2 million, something like that.
Well, see, there were two of them out there. And this very last one was the boyfriend did not like the child because he thought the child may be gay. And the boy had been with the grandmother for a while. It was Gabriel Fernandez, I think, was the first one. That was just horrific. But this little boy, I think he was younger.
Okay, somebody just whispered in my ear, Anthony Avalos. Does that sound familiar?
Yes, that's the youngest one. That was the younger of the two cases that I remember.
Okay.
But why did the judge, if he has the final say-so, why did the social worker blatantly disregarded his ruling and took that child back to the two people that were abusing him?
Okay, so first of all, I don't know that those are the facts, but let's assume that they are. Let's assume that the judge ordered the kid to be returned to stay with the grandparent, and the social worker on their own decided to place the child with the parent.
Yes.
Okay. By the way, that is not something that's unusual to me.
Yeah, me neither.
Occasionally I come across cases where the social worker decides to do something that's contrary to the judge or creates a situation. This is what happens more times than not. Social worker doesn't like the judge's decision.
Right.
And then the social worker kind of sets up the parent to lose the child or, not have the unmonitored visits, and then goes back to the judge and says, basically, see, I told you, you shouldn't have done what you've done or what you did. But the bottom line is that the judge always makes the final decision. There are a couple of rare instances where the judge loses some power to the social worker after the parental rights are terminated. And I'm not talking about those types of cases. I'm talking about cases where the parental rights are still intact. The judge makes the decision about everything. And what happens is people like this grandparent that called me, they wait for months because they're just so disappointed that the social worker said you can't have that child.
Oh, no. You know what? I wish I could pull it up to refer you to it, and I'm going to get someone to check for me because I'm legally blind, so I can't do it myself. But I have a close friend that will go back in the archives, and she will find that case. That grandmother had that child for a while. She was the one that initially called. She made 13 calls to CPS and reported it. And the child had all kind of bruises on him. There were clear signs of it. Their parental rights had not been, taken away. And it shows that these social workers reported that they had gone out to check on the child, and the child was fine.
Right.
But they had never gone out there.
Right.
They made very few. And then the school even reported that the child showed signs of abuse.
Wow.
And still, this baby went back in there. It's a bad system, and it's not helping the kids. Now, a lot of bad parents do not deserve it, but a lot of people there should be an oversight or some kind of commission that would watch these social workers. Like the story you just told. All Jamaicans are drug dealers. What? And she's in control of somebody's child? I got a story about my church, about what happened with a quote-unquote social worker minister. Get out of here. I think you got the loony bins, the crazy people running the loony bin.
Well, that's always the case when something gets really big and gets out of control.
Yeah.
And I think it was the Hoover Commission under Governor Schwarzenegger who wrote a report that said the financial incentives are in the wrong place.
Yep.
You know, the financial incentives are not with keeping the family together. The financial incentives for the counties in California is to, it's to remove the child.
Yes. Yes.
I'm going to tell you a quick story. This happened less than a year ago. Okay, less than a year ago. My engineer is signaling me.
Oh, I'm sorry.
No, that's
all right. I'll listen off the air.
No, you can stay on. This happened maybe a year ago. A guy calls me up to represent him in a Northern California county. He's basically a single parent, and they took the child away from him, and he's trying to get the child back. And when I went up there for the first time, they basically, two of the attorneys laughed at me and made a comment like, "Oh, here's the hotshot or expert from L.A."
Yeah.
Anyway, we did the trial, and after weeks of a trial day here, trial day there, the judge ruled in my client's favor, and returned the child to him. But one of the things that happened, my office routinely sends out what's called a discovery request from the social worker and from different witnesses. Well, we had subpoenaed records from my client's therapist. My client's therapist gave us a bunch of documents and a CD. And I listened to the CD. Now, I don't want to misquote the social worker, and I won't say the county, and I won't say the social worker's name, of course. But basically, this is what happened. The social worker was having a conversation with my client's therapist. And my client's therapist said to the social worker, "I don't know why you're writing these basically negative things about Mr. So-and-so in your reports, because when I'm with him in therapy sessions, I don't see that at all." And at that point in time, they get cut off. All right, the phone dies or whatever, they drop call. The social worker calls the therapist back, because the social worker in this particular county, it's a very small county, and they all know each other, right? Social worker calls back the therapist. And the therapist in the interim had taken another call, so the social worker's call went to voicemail. The social worker leaves a message for the therapist. And this is paraphrasing it, but basically the social worker says something like, "Well, to answer your question, what I wrote in my report is a little exaggeration, because, we're trying to win a case against the father. We think the kid should be suitably placed and stay in foster care." Right?
Yeah.
Now, I don't know this. The client doesn't know this, but the therapist discloses it to us by giving us a CD. And can you imagine? So I didn't really need that, I don't think, in the case, but I did bring it up to the judge, and I recalled the social worker, because we were in the middle of a trial. So I recalled her and I asked her about this. And she gave some cockamamie stories about what she really meant when she left that voicemail message. I'm laughing, but it's kind of sad, because these are public officials given great responsibility and great power. And she was exaggerating because she wanted to win the case.
Thank you. And see, it's a power thing. They don't consider the children. The good parents that are brought up on cases, they don't consider them. There are a lot of bad parents, but there are a lot of parents that really try and get their act together.
Connie, you're so right. So you've heard the story. How does it go? The saying, "Power corrupts, and absolute power corrupts absolutely."
That's right. But you see, it's sad, because we all know there's a problem there, but nobody takes a stand. And then the social workers that did in those two cases, they all they brought charges against them and everything, but that was for a show, because the charges were dismissed.
On the Gabriel Fernandez, it looked like those social workers were going down, and the trial judge made some rulings against them They took it up on appeal, and from what I understand, the Court of Appeals reversed it. Now, I didn't really follow, the situation and really the story.
Because the county guy that's over all the social workers in that area, he said he found no misdoing, even though they had reported being out there to see the child on days that they were not out there. It had been proven.
Right.
So like you said, power corrupts and absolute power completely corrupts.
Right. My engineer is signaling me. Connie, thank you for calling and thank you for listening. Keep listening, okay?
But thank you so much, because I get so much information. But thank you so much for what you're doing, because it's so needed. Mothers and fathers, their kids are being taken away.
All right. Well, thank you, Connie.
Okay, and thank you again.
This is The Secret, How to Fight CPS and Win. We'll be right back with some more calls. This is The Secret, How to Fight CPS and Win. Let's take another call. Here's Kelly from Harbor City. Kelly.
Hello?
Hi, good evening. Did you have a story to tell or a question to ask?
It's a story to tell. It's kind of long, so I'm going to try to brief it up for you.
Go ahead.
Okay, I have an autistic son. He's 20. I've been having a neighbor been harassing me. I guess you can call it harassing, yes. She called the policeman over 60 times. Now we have the PVP appointed trying to remove my son and take my conservatorship away.
Okay, well,
and some of his behavior is due to his vet.
Okay, hold on a second. This is your biological child?
Yes.
Okay. And someone started a conservatorship proceeding to try to take him away from you?
Yes.
Who started that?
It's the PVP appointed. She says she has my son's best interest.
Right. And we know how that goes. So
right.
What is your question?
I need to know, what do I need to do to keep him in the home?
Okay. Is he still in your home?
Yeah, I have a trial coming up this month.
Okay, well, listen, Kelly. That PVP is an experienced attorney.
Mm-hmm.
And experienced attorneys know how to present cases to win.
Yes.
Okay? You need to talk to an attorney so you can come up with a strategy. And if you can afford it, you need to hire an attorney.
Okay.
Now, unfortunately, because your child is an adult and it's not a CPS case, but it basically is. It's not a CPS case. It's happening in the probate court, not the juvenile court.
Okay.
You need to, sit down with an attorney, come up with a strategy, get witnesses, line up your exhibits, send out your subpoenas, because this lady is going to try to, is going to try to take your child away.
Yeah.
That's the bottom line. You can stop it, and you might have the edge because the child is still in your care.
Okay.
All right. If the child were out of your care, you'd be behind the 8 ball. The child's still in your care, so you have the edge, and all you need is a decent strategy, your witnesses, and your exhibits in order to keep this child with you. So call an attorney. If you want, you can call me on Monday, 888-888-6582, and I'll talk to you more about the case.
Okay. All right.
Thank you, Kelly, for listening and calling in. All right, we have time for probably one more call. Mike from Lancaster.
Hello?
Hi, Mike. How are you?
Good.
Did you have a story to tell or a question to ask?
Just question to ask. I don't know. First story. My case has been 3 years old, and I've done everything they've asked to do, and they're trying to take my parental rights and terminate them. And I've done everything.
Okay, is your case up in the Lancaster Juvenile Court?
Yes, it is.
It is. Don't mention any names, but do you have
No.
Do you have an attorney?
Yeah, it was supposed to be an attorney.
A what?
It's one of their attorneys, court-appointed attorney, whatever you call them.
Okay. Yeah. Have you lost your family reunification services? Do you know?
Yes. Yep. I timed out. They said I timed out, and they want to take my kid, terminate parental rights, and I'm doing everything it has to do. I've done everything. Even I'm doing with my son, a counseling with his therapist and me, conjoint counseling. That's what it was.
Conjoint counseling. Okay. How old is the child?
He's 13. And he wants to come home to his dad like he used to be.
Okay. Well, just between you and I, it's going to be pretty hard. I mean, it's not impossible, but it's going to be pretty hard for them to terminate your rights if he's 13 years old, right?
Yeah, he don't want. They've asked me if he wanted to be adopted out, and he said no, he didn't want to be adopted out. He told them.
But Mike, I'm telling you this: it's not impossible. They could do it. It's just, it's harder when the child's 13 and wants to come home versus when the child is 3 years old and can't say anything. But this is what you have to do. We're in the middle of a pandemic. You can't go down to
I can't see my son yet. I haven't seen him or nothing now. No visits, nothing. They're all been cut off.
Okay, Mike, do you want me to tell you what you should do?
What?
I'm going to tell you.
Emergency order? What? Emergency order.
No, I want you to email your attorney.
Email?
Mm-hmm. Email your attorney and tell your attorney that you need to have a conversation about developing a strategy to get the child back in your home. Okay? Just a simple email like that.
Yeah.
All right?
My attorney email?
No, email your attorney.
Attorney.
Okay. And tell him or her that you need to have a phone meeting to develop a strategy to get your child back in their home.
Yeah.
All right?
Okay. Yeah, since I can't talk to nobody. And they postponed the court till September 15th. September 15th.
Do you know what type of hearing it's going to be in September?
It's a review hearing and one where, reviews it and decides if you take my parental rights or whatever he's doing.
Okay, but you've lost reunification services, right?
Yeah.
Okay, so you got to talk to your attorney about filing a 388 petition. Because you have the prime. I don't know all the facts of your case, but you have one of the prime cases, or cases where the kid is 13 years old and wants to come back home. So you should.
There's no reason he can't. I've got housing. I got everything.
Okay. Well,
there's no reason he can't come. That's what I understand it. Where they're trying to terminate parental rights and adopt them out.
Yeah, they could do that, but it's going to be hard to do. All right. Yeah. So, would you promise me on tomorrow or tonight you'll email your attorney?
Email? I'll get your email address. I don't have it. I'm sure it's on the card, I hope.
You what?
It's probably on some of my paperwork or email. It's got to be on my paperwork, I hope.
Okay, do you have the attorney's card?
Yeah, I think so. I'll have to get her email and then do that. Yeah, because I never emailed her.
Okay, and this is what you can also do. You can also look her up on the internet.
Yeah.
And
it'll tell me.
Yeah, and they're supposed to. They usually have the attorney's email.
Yeah, because it should be open. Okay, cool.
Okay, but there's a reason why.
Response, nobody else is answering.
Yeah, there's a reason why I want you to email is because there will be a digital record of you trying to communicate with the attorney.
Okay.
Okay. You calling the attorney and leaving a message, that's nothing, right? That's worthless. Email, digital.
I can't get hold of nobody. Nobody from CPS. They're not answering. I haven't seen a social worker or nothing.
Mike, I didn't tell you to get in touch with the social worker. And I'm not telling you, until you talk to your attorney, I suggest you not try to talk to the social worker. Talk to your attorney first, okay?
Okay. All right.
Hey, Mike, I want to thank you for listening and calling in today, and keep listening, okay?
All right, thanks.
All right. We're running out of time. I do want to remind people, especially in California and in a lot of states, judges are elected. So if you don't like what a judge is doing, you should maybe get a voting group together and vote for the judge that you want that would be fair. Also, juvenile dependency laws in the state of California are made by the California legislature. If you are not happy with certain laws right now, you can contact your state legislator or your state senator and by way of mail or email and make complaints. I want to thank everybody for listening. This has been our new format of 2 hours, 2-hour show. So we'll see you next week on the radio at 7 p.m. Pacific Standard Time.